Well, good evening, everyone, and welcome back to AJ103 Criminal Evidence Online. Tonight's lecture is going to cover Chapter 4, Types of Evidence. And as with a lot of the other chapters, we have a lot of ground to cover, and the featured case is actually a little bit longer than some of the other ones. But this featured case is super interesting, and I would highly recommend that you look at it because from an evidentiary standpoint, it's going to make you wonder why some individuals don't get convicted. And you'll hopefully be able to kind of look at both sides of the coin, if you will, when you're looking at this particular case. So with that being said, let's kind of dive right into Chapter 4. In 2008, Casey Anthony was arrested for the murder of her 2-year-old daughter. And some evidence pointed towards guilt, but all of it was basically circumstantial. And witnesses for both sides gave contradictory and confusing testimony. And during the opening statements here, the prosecution claimed that Casey Anthony suffocated her daughter with duct tape. And the defense opening statement claimed that Kaylee had accidentally drowned in her grandparents' backyard swimming pool. It also alleged that Casey behaved so strangely because she had been sexually abused by George Anthony, her father, throughout her childhood. And there's just so many ins and outs to this particular case. But the trial lasted about 32 days, and there were 349 pieces of evidence for the jury to think about and consider. And deliberations lasted 10 hours and 40 minutes. And Casey was subsequently acquitted on all charges except a few misdemeanors involving giving false information to law enforcement officers. Now, I invite you to look at the two links that I have, and I think them have, okay, right here, to the Casey Anthony case, and think for yourself about the level that the jury would have to evaluate all the different types of evidence, and perhaps based on what you see in these two videos, what verdict might you possibly return on this particular case. So a lot of this trial was also, there were some issues around the media. And this Anthony case was widely publicized, and many people felt there was strong evidence to support her guilt. A jury, however, we have to remember, starts from the premise of innocence. And after you watch this, what fact or facts do you think most strongly pointed to her guilt? I'm sorry, and then what fact or facts do you think the jury relied upon to proclaim her innocence? So super cool trial, and I would recommend highly that you watch it, and then maybe shoot me an email with your opinion, or pop it on our MSJC Criminal Justice Club website. So here's what we're going to try to learn today, and again, we have a lot of ground to cover in 60 minutes. Define and describe what is relevant and material evidence, and those are definitely necessary for this particular context of our chapter. Define what direct evidence is, or what is direct evidence, and how it differs from circumstantial evidence. And explain real evidence. What does that mean? Like there's fake evidence? So we're going to explain what real evidence is. And give examples of what testimonial evidence is, and define some things like stipulations and judicial notice and presumptions, and explain how those are used at trial. So in the study of the rules of evidence, there are several basic terms that must be understood before discussing specific issues. And this chapter discusses the more important of these specific issues, or key terms, if you will. And one of the basic concepts of evidence is that only relevant evidence is admissible in court. Well, and that may sound just kind of like sensible. Yeah, sure, right. Only relevant evidence is admissible in court. There are situations, however, in which even relevant evidence may not be admitted. And one is when the evidence was obtained, of course, in violation of a defendant's constitutional rights, and that therefore, even though it's relevant, if it's obtained illegally or improperly in violation of somebody's constitutional rights, where it's going to be excluded. And this rule is discussed in great detail in a few chapters down the line. Now, two other common reasons for excluding evidence are violations of the hearsay rule, which we'll talk about in Chapter 9, and the fact that the information is privileged, and we can find that in Chapter 10. So to put it simply, something is relevant if it tends to prove or disprove something that is disputed in the case. Now, again, a little confusing, but hang with me for a minute. Now, one of the keys to what is relevant is the question of what is at issue in the case. And at issue refers to all the disputed facts that are needed to establish the elements of the crimes charged and the defendant's guilt beyond a reasonable doubt. Facts necessary to establish the defense are also at issue. So here's kind of an example. When a defendant enters a plea of not guilty, all of the facts needed to establish the crime charged are in effect disputed because the person is pleading not guilty. Does that kind of make sense? And evidence can be admitted to establish them, to establish those facts. If the prosecution believes it is necessary, more than one witness may be called to testify about the same fact or event. And on the other hand, if the defendant admits something such as the prior conviction, the facts regarding the crime that resulted in that conviction are no longer at issue. No evidence can be admitted to prove facts that are not at issue. And again, I know it kind of is difficult to understand, but put it as simply as possible, something is relevant if it tends to prove or disprove something that is disputed in the case. So one of the keys to what is relevant in the case is the question of, well, what is at issue? And we just kind of talked about that. At issue refers to all disputed facts that are needed to establish the elements of the crime charged and the defendant's guilt beyond a reasonable doubt. The facts necessary to establish the defense, are also at issue. And when that defendant again enters a plea of not guilty, all of the facts needed to establish the crimes charged are in effect disputed. But evidence can be admitted to establish them. And the prosecution, again, if they believe they need to, more than one witness can be called to testify about that same fact or event. And on the other hand, that if the defendant admits to something, the facts they're no longer at issue. So no evidence needs to be admitted to prove that particular fact. Does that kind of clear it up a little bit? We'll consider the Casey Anthony case. There was a lot of evidence showing she lied to her parents and the police about where her daughter Kaylee was. And there was also a lot of evidence showing that Casey did behave like a grieving mother. But did the evidence really show that Casey killed Kylie? And that's kind of what it comes down to. Was there evidence that Casey killed Kylie? And once you watch the videos, you'll be able to kind of tell me. So relevant evidence, by definition, evidence that makes any fact important to the case more or less likely. and it falls under the federal rules of evidence. We've talked about the FRE before. So another key to admissibility, we've talked about one, and another one is going to be what they call probative value. And this means that that the evidence must make it appear that a fact is probably true. And sometimes there is one piece of evidence that conclusively proves the case. And this is usually pretty rare. More commonly, however, there are a variety of pieces of evidence that, when considered all together, convince the jury that the defendant is guilty beyond a reasonable doubt. And it is difficult to decide what weight any one piece of evidence will have in convincing the jury that the defendant is guilty or innocent. And any evidence that might have some impact on the jury has probative value. And if an attorney makes an objection based on the lack of evidence, the judge then has to decide if the evidence is likely to have any effect on the jury. And if not, the evidence is going to be admitted. And this determination is made on a question-by-question basis during both direct and cross-examination. So I said all that to say that relevant evidence is probative if it offers some proof that a fact did or did not occur. And probative value means evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. And yes, it's legalese, and that's another reason why you really need to kind of read in your textbook. Now, again, more commonly, there are a variety of pieces of evidence that, when considered all together, will convince the jury that the defendant is guilty beyond a reasonable doubt. And it is difficult to decide what weight any one piece of evidence will have in convincing the jury the defendant is in fact innocent or guilty. Now, if you look on page 92, you're going to see some examples of relevant evidence in a murder trial, and perhaps that will help you kind of get a better understanding of what we're talking about. So what about some objections and relevancy? Well, evidence that is not relevant is not admissible. And an attorney may object and require the judge to rule on the relevancy of any evidence. And if there is no objection, then of course no proof of relevancy is needed. And along with that, relevant evidence must also be what they call material. Now, I'll give you some examples here of relevant evidence in a murder trial, and I told you that you can find it on page 92, but the defendant's fingerprints were on the murder weapon. Defendant bought the murder weapon a week before the victim died. Tests showed gunshot residue on the defendant's hands. So all of these, this would all be relevant evidence in a murder trial. So applying the law to what is relevant, some questions. Isn't it true that any information can only help make a decision? Why is it then some information is kept from the trier of fact? Why don't we just give them everything? And how can a judge not use evidence he has already heard, even if he ruled it irrelevant? Meaning that you simply can't forget what you've heard. So think of those things as we start to kind of move through the chapter. And now material evidence. So we've talked about this relevant evidence. Well, relevant evidence must also be material. And, well, which means it's logically connected to a relevant fact in the case. And material evidence, as I said, has some logical connection to the facts of the trial and affects whether they can be shown to be true or false. And evidence that has no connection is basically considered immaterial. So relevant evidence is not admissible if it would unduly prejudice or unduly prejudicial due to its emotional impact on the jury. Now, the court is cautious about admitting evidence that if it would likely arouse either hostility or sympathy towards one side or another. And the defendant's prior convictions are in this category. And in most cases, the prior conviction has only slight relevance, but the chance that the jury will believe the defendant was more likely to have committed the current crime merely because of the prior conviction is quite a bit higher. Okay? And on the other hand, pictures of the murder victim may arouse the hostility of the jury towards the defendant, but they are usually admissible because of their greater relevance to the case. Color photos are now the norm, but prosecutors do face restrictions on the size of the pictures, and judges usually limit the number of glory pictures that can be admitted at trial. Now, in the Casey Anthony case, the prosecution was allowed to introduce many photographs of Kaylee's skeletal remains and an animated 3D fly-through, if you will, video of the location where her remains were found. So material evidence in practice, okay, relevant evidence is material only if it meets both of these tests right here. And the first one is it must be relevant to some fact that is at issue in the case. And second, it must have more than just a remote connection to the case. So material evidence defined. Evidence is material if it is logically connected with some fact at issue. And in practice, relevant evidence is material only if it meets the two things that are listed here. Relevant to some fact that is an issue in the case, and it must have more than just a remote connection to the case. So what about the exclusion of evidence? Does everything just get in? Or is there an exclusion that could take place? Well, exclusion of evidence is kind of a balancing test. And judges look at the impact of the evidence. Will the evidence be unduly prejudicial due to its emotional impact on the jury? Or will the photos or whatever we're going to show bring hostility or sympathy to either side, which I've kind of mentioned? And this can always be found in the FRE in section 403, exclusion of otherwise relevant evidence. And we talked a little bit about what was allowed to be introduced in the Casey Anthony case. So keep in mind that, again, relevant evidence is not admissible if it would be unduly prejudicial due to its emotional impact on the jury, or if it brings forth hostility or sympathy. So what are some typical cases of exclusion? Well, prior convictions, like we talked about, of crimes not closely related in a manner or time to the current case. Could this show the defendant was more than likely to commit a crime just because he has a prior conviction? Basically, evidence that distracts from the main issues at trial. And again, judges will limit the number of gory photos or pictures and there are restrictions on the size of these types of pictures as well. And we talked a little bit about the photos in the Casey Anthony case. And here's a couple of pictures that were actually used. The one on the right was from the flyover that was done that showed the remains of the child. And to some degree, you have to be able to get some of these pictures in there to be able to make your case. But again, if they are unduly prejudicial, then there's a possibility that those photos would have to be, may not be allowed to be accepted into evidence. So now that we kind of have a little definition and hopefully an understanding of like relevant evidence and what is probative value and what is material, what does material evidence mean? Well, let's look at the difference between cumulative and corroborative evidence. Now, cumulative evidence merely states that what has already been admitted into evidence and therefore may be excluded. So cumulative evidence repeats other evidence or facts. So for example, if there are 10 witnesses to the same crime and they all basically gave the same account of what happened, their testimony would be what we call cumulative. And how many eyewitnesses or witnesses that would be allowed to testify would be up to the judge, and probably after about, say 2 or 3 have said the same thing, the judge would probably sustain an objection that the testimony is merely cumulative and should not be allowed. Now, on the other hand, if their testimony corroborates what has already been introduced, this in fact is usually admissible. So we know what cumulative is, and that's on page 94. There are some examples at the top. Well, the distinction is that cumulative evidence just repeats the same thing that has already been said, whereas corroborative evidence supports prior testimony by providing additional facts. And corroborative evidence adds new facts and confirms more evidence. And this type of corroborative evidence is in fact more likely to be admitted versus the other one. And on page 94 will be some examples or some additional examples of corroborative evidence. But I'm going to give you 1 or 2 anyway, and I didn't know that I was going to do that, but here you go. So Adam testified that he was at 1st and 2nd at midnight on November 3rd, and he saw a red car speed past. And as it went by, someone threw an apparently empty bank bag, is what that's supposed to be, out of the window. So that's the first testimony. And then Sam testified that he walked through the intersection of 1st and 2nd at 11:55 on November 2nd. So you can see a couple of different things that are adding to the circumstances, right? On his way to the store to buy cigarettes. And he saw nothing on the ground. So he's helping to set a time frame on when this car or this bank bag may have been like viewed or thrown out of the car, because that wasn't listed in the first person's testimony, in Adam's testimony. And on his way home, 10 minutes later, he found an empty bank bag in the street. So through this testimony, we are corroborating Adam's testimony about the car that sped past and that he saw somebody throw something out of the window. And we're kind of throwing in the fact that now we're giving some times. And we're adding times to this and some more detail. So we're corroborating the statements. And then finally, Tom testifies that he is the owner of the store on the corner of 1st and 2nd. And there are records that Sam used a debit card to buy cigarettes at 11:58. So now we've been able to corroborate that, in fact, Sam went to the store because his debit card was used. So can you see how these examples kind of corroborate each other? And I hope that you can, so not a bad example. So we now know what corroborative evidence is, and we have some examples, and we know what cumulative evidence is. So now we're going to look at something called direct and circumstantial evidence. And one method of classifying evidence divides all evidence into two types, direct and circumstantial. And a conviction can be based on either direct or circumstantial evidence, or a combination of both. In other words, either the evidence established that a fact exists, which would be direct, or the jury needs to draw an inference based on the evidence in order to conclude that a fact exists, and that would be circumstantial. Now, the defense attorney's favorite argument, it is only circumstantial evidence, may be reassuring to the defendant, but it is legally possible to convict a person solely on the basis of circumstantial evidence. But then on the other hand, you look at the Casey Anthony case, and you can see that there wasn't sufficient circumstantial evidence. So hopefully that kind of shows you the difference between the two. Now, direct evidence is evidence that conclusively establishes something as true, if it's believed by the jury, of course. And direct evidence of a fact and issue is always relevant. And based on personal knowledge or observation of the person testifying, no presumption or inference is needed. So when you're talking about direct evidence, it's based on personal knowledge or observation of that individual testifying. So people don't have to presume or draw an inference, if you will. So in a criminal case, direct evidence usually involves eyewitness testimony regarding the commission of a crime. For example, it would be considered direct evidence if a witness testified that he saw the defendant shoot the murder victim. And if the jury believes the witness is telling the truth, it has no choice but to conclude that the defendant shot the victim. On the other hand, it is only circumstantial evidence if the witness testified that he heard a gunshot and ran to the scene of the crime just in time to see the defendant run from the location with a smoking gun in her hand. Now, this is not direct evidence because it is necessary to draw a conclusion from the facts, namely that the person with the smoking gun is the same one who shot the victim. Does that kind of make sense? And I think it should. So direct evidence based on personal knowledge or observation of the person testifying, no inference or presumption is needed. And if the testimony is believed by the jury, the fact it relates to is conclusively established. And circumstantial evidence is what indirectly proves a fact. It's based on an inference that the jury must draw rather than personal knowledge or observation. Well, what is an inference? And I'm trying to see if I go over it. Well, again, circumstantial evidence is evidence that indirectly proves a fact. It requires the jury or judge to make an inference or deduction. It's not grounds to object to the admission of evidence simply by stating that it's circumstantial. And we talked about some examples here. I gave you one. Let's see if we have some others. So the defendant was seen running from the scene immediately after a crime occurred. Is that direct or circumstantial? Just because they were running? Well, it's circumstantial in the fact that the inference is that the defendant committed the crime because he was seen like running. Well, how about a man working at the scene of a robbery, hid behind a large box and watched as the robber shot the clerk who wouldn't hand over the cash? Is this direct or circumstantial? Well, it'd be direct because there's no inference. I think you're getting it now. He was a witness to the shooting if the jury believes him. And that's the other thing. The jury actually has to believe. So what's the inference? Well, this is a logical conclusion that a person can make based on a fact or group of facts. And in the example of the woman with the smoking gun, it is a logical conclusion that she shot the victim if there was no one else at the shooting scene between the time that the gunshot was heard and the time that she was observed running away with the smoking gun. The jury will make the final determination on whether to draw this inference. The defense may be able to offer a logical explanation for her conduct that might convince the jury that someone else actually shot the victim. And circumstantial evidence may be so strong that it is nearly conclusive or so weak that it's immaterial. There are many common situations in which circumstantial evidence is used in criminal cases. And some states have enacted these into law. And others merely allow the jurors to use their common sense and draw logical inferences. And admissibility, again, of weak circumstantial evidence is at the discretion of the judge. So now what about testimonial evidence? So we've kind of gone through several different terms, and let's talk a little bit about this thing called testimonial evidence. Well, another method of classifying evidence is by the way it is presented in court, and there are a variety of terms that are used for this purpose, and this book uses the following terms: testimony and real. And kind of note that this is a separate classification system. Now, an item such as the defendant's gun that was found near the murder scene can be correctly classified as both circumstantial evidence and real evidence. But the key concept in testimonial evidence is that a person is testifying under oath or affirmation. And this can occur in court or before court in something called like a deposition. But to be testimonial, each must be under oath. So all evidence must be introduced through the testimony of a person on the witness stand. The verbal content of what a witness says is testimonial evidence, and this includes both direct and cross-examination. If the witness tells about seeing the defendant shoot the victim, this is testimonial evidence. However, if the gun is admitted into evidence, the gun is real evidence. Now, to qualify as testimonial evidence, the witness, again, must be under oath or affirmation. And this is commonly done by swearing in a witness prior to taking the witness stand in court. And written statements made out to court under oath or affirmation are called affidavits. These are documents that are used, that are made to support probable cause for issuing things like search warrants, and that's a good example for that. And depositions are these pre-trial procedures frequently used as part of discovery in civil cases, and an attorney for each side will have a stenographer and have the person placed under oath and ask questions. So testimonial evidence is very, very crucial. So the other method that we're talking about here of classifying evidence is by the way it's presented in court, as I just said. So it can be real or testimonial. And the key concept, again, in testimonial evidence is that a person is testifying under oath or affirmation. And on the other hand, because I know there's some confusion, real evidence defined as physical evidence that itself plays a direct part in the incident in question, including physical evidence, demonstrative evidence, and tangible evidence. In other terms, are called physical evidence and demonstrative evidence and tangible evidence. So there's some different words to use as well. So there is some confusion regarding the correct term for objects that are admitted into evidence. And again, real evidence, physical evidence, demonstrative evidence, and tangible evidence are all commonly used terms. And various authors define one term so that it includes all the others. So you should be aware that the previous terms frequently are used kind of interchangeably. And documentary evidence, which we'll get to in a few minutes, is a subgroup of real evidence. So what's real evidence defined? It's physical evidence like clothing or a knife or a needle or something like that itself plays a direct part in the incident in question. And on page 99 are some more examples of real evidence. So this photograph would depict an individual that's testifying about real evidence, like a knife or a gun. Again, that itself played a direct part in the incident in question. So applying the law to real versus testimonial evidence. Now, recently a number of men convicted of crimes have been released when DNA evidence seemed to contradict their conviction. Well, how much weight should testimonial versus real evidence be given? And is real evidence somehow better? And what practical standards should we use here? So those are just food for thought questions. Well, what are some substitutes for evidence? And can we substitute during any times? And again, if I didn't point it out, I just want to make sure that I do. Page 99 gives you examples of real evidence. Physical items, guns, knives, clothing, key to a safe, documents, would consist of things like checks or contracts or letters or ransom notes, fingerprint cards, computer files. Exhibits made for trial would be like models and scale drawings and charts, and pictures would be like still photos and videos and digital images and x-rays. So those are examples that are all under the real evidence umbrella. Now, there are some situations in which the jury is specifically told what facts to believe rather than having the opposing sides introduce evidence on the issue. And these can be divided into three categories. They're called either stipulations, judicial notice, or presumptions. Now, a stipulation is an agreement between the prosecution and the defense to admit one or more facts into evidence. They agree on it, and these stipulations can be written or oral, and typically they are made before trial, and they're often used to simplify or speed up the proceedings. So that would be a stipulation. Now, judicial notice is a procedure in which the judge tells the jury to conclude that a certain fact exists. And the jury is required to follow that instruction in civil cases, but it's only advisory in criminal cases. And the idea behind judicial notice is that it's a waste of time to require proof of commonly known facts. So an example could be, if a burglary occurred at 2 a.m. in January, it's logical to conclude that it occurred at night. And it doesn't require any type of testimony on the issue of, like, what is nighttime. And I know that sounds kind of funny, but that's how this judicial notice issue kind of works. And then finally, we have what is called a presumption. And when a presumption is involved, the judge instructs the jury to draw specific conclusions from the facts. And unlike stipulations and judicial notice, in order to use a presumption, the attorney must convince the jury that at least some of the facts exist. And when discussing presumptions, two terms usually are commonly used and kind of come to mind. The basic fact term is that fact that must be established in order to use a presumption. And the presumed fact is the fact that the judge will tell the jurors that they must assume happened if that basic fact is established. Now keep in mind, if the basic fact is not established, the presumption cannot be used, but jurors can draw logical inferences, because they're allowed to do that, from the facts introduced at evidence. So a presumption is a legal inference or assumption that a fact exists based on the known or proven existence of some other group of facts. And I understand that this could be totally confusing. And here's a little chart to try to help you. It's on page 104 in chapter 4 that talks about presumption. So I'm not going to go through the whole thing. I'll let you look at this at your leisure, but you have this chart here which will help you deal with this conclusive presumption, the strong rebuttable presumption, and a weak rebuttable presumption. So hopefully that helps a little bit. And then we have this case of Francis versus Franklin. And in this case, the defendant was on trial for capital murder. And as a prisoner, he escaped custody and fled to a private residence. Now, the defendant shot through a closed door, killing the deceased when the victim refused to turn over his car. And at trial, the defendant's sole defense was that he did not intend to kill. Now, the judge's instruction allowed the jury to presume the intent to kill. Well, the Supreme Court got a hold of this case and basically overturned the conviction, because such presumptions cannot be mandatory. You can draw an inference from it as a jury, but you can't mandate basically that this type of presumption be assumed by the jury. So take a look at this Francis v. Franklin case. It really does talk a little bit more about presumption, and I think helps clear up a couple of different definitions as well. So how do we apply this, the mens rea, if you will, the mental state of mind? So traditionally for a crime, you had to have both the physical act and the mental state of mind, that mens rea, and we'll learn more about that. However, it seems that we're moving towards a approach of what we call strict liability, like no such mens rea. So is the intent to commit an act worth keeping in the criminal law? And how much impact should intent have on charges, conviction, and punishment? And I'll leave you with the code section to look up, and perhaps we'll discuss it later. Penal Code 261.5. Read the definition of that, and perhaps we'll have a discussion about that particular section and this state of mind or intent, and whether it's worth keeping or not. So some finishing up here on some limitations on presumptions. There are 3 constitutional limits on presumptions. A presumption must be based on a logical assumption rather than mere policy. When used by the prosecution, the basic fact must be established beyond a reasonable doubt, and a presumption cannot shift the burden of proof to the defendant. And then finally, all right, we have a couple to go. We'll look at another case here, In re Winship, which is a juvenile case. So during a juvenile hearing, the state sought to convict a teenager under a lesser standard of proof. And in this case, the Supreme Court ruled that every essential element of a crime must be proven, and that a presumption of innocence is a foundation of American law. And what types of presumptions are there? Well, there are two general types of presumptions. There's rebuttable and conclusive. And rebuttable may also be divided into strong and weak. And for each, you're going to still need to prove the basic fact before the presumed fact may be considered. So how do we apply the law in this hidden element? Well, the elements of crime rarely contain motive as an element, yet it seems critical in finding guilt. And is it likely that a person would commit a crime for no reason whatsoever? And does this mean that motive has to be proven in order to convict in a crime? And does the lack of motive mean that someone is innocent? Or does a strong motive really prove guilt? And we'll talk more about motive in some other chapters as we kind of continue our chapter lectures. So this is going to be the end of chapter 4 as it relates to types of evidence. And again, I know that some of these phrases and definitions get a little tricky, and sometimes they can get a little gray and you get mixed up. And that's why it's really good, as I said, to read the textbook so you have a little bit of a better understanding and look at some of the examples that are in the textbook. I can tell you one thing that this book does well is it does give you examples of, let's say, cumulative evidence, and examples of relevant evidence, and examples of direct and circumstantial evidence, and examples of real evidence, and examples of stipulations, and examples of items that are subject to judicial notice. And then we had that chart in there that helped you deal with the presumptions. So go through those. And most of all, take a look at the key terms that are located at the beginning of the chapter, and also the discussion questions that are located at the end of the chapter. So with that being said, that will conclude our lecture for chapter 4, types of evidence. If you have any questions, please post them on the discussion board. If you don't want to post them there, feel free to send me an email. And with that, until next time.